What if the most powerful thing a man ever wrote in his entire life was not a legal brief, not a confession, not a letter to a judge, but a few torn pages scratched out on a yellow legal pad the night before the state came to take his life? What if inside those pages was a secret, a psychological secret, a legal secret, that the entire machinery of the American justice system had spent decades hoping you would never read? This is Letters from Death Row, and today we are going deep inside Angola Prison, officially known as Louisiana State Penitentiary, the largest maximum security prison in the United States, a place built on the bones of a former slave plantation, a place that currently holds 56 men on death row, men who have been waiting, some of them for over 20 years, for the state of Louisiana to carry out their sentences. This is a prison documentary about what happens to the human mind when it has nothing left but time and a pencil, and what men choose to say when they know that the next morning may be the last morning they ever see. But here is the question we are going to answer together before this documentary is over, and I need you to stay with me because the answer will genuinely change the way you think about justice, psychology, and the legal system in the United States. The question is this: are these final letters simply the last words of guilty men saying goodbye? Or are they something far more calculated, far more psychologically complex, and far more legally dangerous than anyone in power wants to admit? Stay with us. Because by the time we reach the final letter, you will not see this the same way again.
If you enjoy real, gripping prison documentaries and true stories, don't forget to like this video, leave a comment, and share it with your friends and family. Hit that subscribe button and turn on notifications so you never miss more shocking and exclusive content.
To understand what is happening inside Angola Prison right now, in the spring of 2026, you have to go back. Not just to the crimes. Not just to the courtrooms. You have to go back to the moment before everything broke, the psychological fracture point, the place where a human life first began to come apart at the seams. Because the letters these men are writing today, the letters we are going to examine in this documentary, do not begin on death row. They begin decades earlier, in moments of chaos, poverty, trauma, and a justice system that was moving at full speed in a direction that many legal scholars are now calling deeply, structurally flawed. Angola Prison sits on 18,000 acres of land in West Feliciana Parish, Louisiana. It is the largest maximum security prison in the entire United States, and it is not just large in terms of its physical footprint. It is large in terms of its weight, the psychological, historical, and legal weight that it carries. The land itself was a working plantation before it became a prison. The fields that once grew cotton under the hands of enslaved people are the same fields where inmates still work today, under the Louisiana sun, in a state that has one of the highest incarceration rates in a country that already has the highest incarceration rate in the entire world. When you walk onto the grounds of Angola, you are not simply walking into a modern correctional facility. You are walking into one of the most layered, most historically dense, most psychologically complex institutions in American history. And somewhere inside that institution, right now, 56 men are waiting. But who are these men? And more importantly, who were they before Angola made them into a number? This is the question that mainstream crime coverage almost never asks. The headlines focus on the crime. The courtrooms focus on the evidence. The state focuses on the sentence. But the psychologists, the criminologists, the behavioral researchers who have spent careers studying long-term death row populations, they ask a different question entirely. They do not ask what these men did. They ask what happened to them first. And the answers to that question form the invisible foundation underneath every single letter being written on death row today. Study after study of long-term condemned populations in the United States has found a pattern so consistent that researchers have stopped calling it a coincidence and started calling it a pipeline. The overwhelming majority of men on death row, not some of them, not many of them, but the overwhelming majority, entered adulthood having already experienced profound, repeated, and unaddressed psychological trauma. Childhood abuse. Extreme poverty. Exposure to violence before the age of 10. Neurological damage from lead exposure in deteriorating housing. Educational systems that were underfunded to the point of collapse. Mental health conditions that were never diagnosed, never treated, never even named. These are not excuses. That is a critical distinction we must be clear about from the very beginning of this documentary. Explaining the psychology of how someone arrives at a catastrophic act of violence is not the same as excusing that act. The victims of the crimes that put these men on death row were real people. Their suffering was real. Their families carry wounds that do not heal. We will come back to that. We must come back to that. But if we are going to understand what these final letters actually mean, if we are going to understand why a man who has been in solitary confinement for 23 years writes what he writes on the last night of his life, we have to understand the full arc of how he got there. Now, here is the first thing that will genuinely surprise you about the Angola death row population specifically, and this is something that very few mainstream outlets have covered in depth. The current group of condemned men at Angola is not a recent collection of cases. These are not men who were convicted in the last 5 or 10 years and are now facing relatively swift execution timelines. The 56 men currently on Angola's death row have been there, on average, for over 2 decades. Some of them have been there for longer than some of you watching this documentary have been alive. And that specific fact, that extraordinary length of time between conviction and execution, is not just a logistical detail. It is a profound psychological reality that changes everything about how we must read their letters. Psychologists who specialize in what is called death row phenomenon, a term that has been debated in international human rights courts, including the European Court of Human Rights, describe something very specific that happens to the human mind when it is placed in a small concrete cell, cut off from natural light, cut off from normal human contact, and told to wait. Not for days. Not for months. But for years. For decades. The mind does not simply pause and wait alongside the body. The mind continues to move. It continues to process. It continues to search for meaning, for narrative, for a way to organize the overwhelming psychological experience of living every day with the knowledge that the state has designated you for death and is simply deciding when to act on that designation. Researchers have documented a specific psychological progression in long-term death row inmates that moves through recognizable stages. In the early years following sentencing, the dominant psychological state is typically one of hyperactivated legal focus. The mind throws itself into the case. Appeals, motions, evidence reviews. There is an almost manic quality to this phase because the mind has found a purpose, fighting the sentence, and that purpose provides a psychological anchor. This is the phase where the letters are full of legal language, case citations, procedural arguments. The man is not yet writing about his soul. He is writing about his case. But as the years accumulate, and as appeal after appeal is denied, something begins to shift. The legal focus does not disappear entirely, but it begins to compete with something else. Something deeper. Something that the legal system has no framework to process and no interest in addressing. The condemned man begins, slowly and often painfully, to turn inward. The letters begin to change. The language begins to change. And this is precisely where what researchers now call the neutralization phenomenon begins to emerge, and this is the first major secret of this documentary, so pay close attention to what comes next. In 2024 and 2025, a team of forensic linguistics researchers conducted a systematic analysis of final statements and pre-execution correspondence from long-term death row populations across 5 American states, including Louisiana. What they found was remarkable. They found that inmates who had been on death row for 20 or more years showed a statistically significant shift in the linguistic patterns of their letters as their execution dates approached. The letters stopped sounding like the letters of guilty men performing remorse for an audience. They started sounding like something else entirely. They started sounding like the letters of men who had undergone a profound and genuine psychological reconstruction of their own identity and their own understanding of what had happened in their lives and in the lives of the people they had harmed. The researchers called this pattern moral decoupling through neutralization syntax, and it is one of the most psychologically complex phenomena documented in correctional psychology in the last decade. What it means, in plain language, is this. After 20 or more years of isolation, reflection, and the particular kind of psychological pressure that only comes from living inside a death sentence, certain men begin to reframe their crimes not as expressions of their own individual evil, but as the final, catastrophic output of a system of failures. Failures of family, failures of community, failures of mental health care, failures of education, failures of poverty policy, that converged on a single terrible moment. They do not say they did not do what they did. They say that who they were when they did it was itself the product of forces that no one ever tried to stop. Now, is this true? Is this a genuine psychological insight, or is it a sophisticated manipulation? That is exactly the question we are going to sit with throughout this documentary, because the answer is not simple, and anyone who tells you it is simple is not being honest with you. What we can say with confidence is this: the linguistic patterns researchers identified in these letters are not the patterns of calculated manipulation. They are the patterns of genuine long-term psychological processing. They are the kind of language shifts that forensic psychologists associate with authentic cognitive reconstruction, the kind that happens in long-term therapy, in sustained religious practice, in the slow grinding work of coming to terms with the worst thing you have ever done. But they are happening inside concrete cells. They are happening without therapists, without adequate mental health support, without any of the institutional scaffolding that usually accompanies this kind of psychological transformation. They are happening because the human mind, even under the most extreme conditions, does not stop trying to understand itself. And that is what makes these letters so extraordinary, and so legally dangerous. Here is something that Angola's administration and the Louisiana Attorney General's office understand very well, even if they do not discuss it publicly. A letter written by a man in the first year after his conviction is one kind of document. It reflects the psychology of a man in crisis, a man in shock, a man whose identity is still the identity he carried into the courtroom. But a letter written by that same man after 23 years in solitary confinement at Angola is a completely different kind of document. It reflects the psychology of someone who has been fundamentally, irreversibly changed by the experience of incarceration itself. And this raises a question that philosophers, legal scholars, and human rights advocates have been arguing about for decades without resolution. If the person who committed the crime and the person currently sitting in the cell are psychologically, cognitively, and morally so different from each other that they barely share the same inner life, what exactly is the state executing? We are not going to answer that question today. That question does not have a clean answer. But we are going to show you the letters that force you to ask it. Now let us talk specifically about the current situation at Angola in 2026, because the timing of what is happening right now is not accidental, and understanding the timeline is essential to understanding why these letters matter so urgently at this particular moment. For 15 years, Angola carried out no executions. 15 years. There were legal challenges, moratoriums, debates about the constitutionality of the state's lethal injection protocols. For 15 years, the men on death row continued to age, continued to write, continued to wait. Then, in 2024, the state of Louisiana introduced nitrogen hypoxia as its primary execution method, a protocol that uses a flow of pure nitrogen gas delivered through an industrial-grade full-face respirator mask to cause death by oxygen deprivation. The state argued it was more humane. Civil rights attorneys argued it was untested, unpredictable, and potentially constituted a form of torture under the Eighth Amendment. The debate was fierce, the legal battles were immediate, and the executions resumed. And now, in 2026, Louisiana Attorney General Murrill is moving aggressively to work through what officials are calling the backlog. 56 men with active death sentences, some of whom have been waiting for their execution date for longer than most Americans spend in any single phase of their adult lives. New execution warrants are being drafted. New dates are being set. The machinery that was dormant for 15 years is running again, and it is running fast. This is the context in which the letters are being written right now. Not in the abstract, not in the historical past, but right now, in the spring of 2026, men in Angola's death row unit are picking up their pencils and writing on their yellow legal pads with a new and terrible urgency. Because the dates are becoming real again. The gap between the sentence and the execution, which had stretched so long that some men had begun to psychologically normalize their imprisonment and build a kind of life within it, is collapsing. And the letters that are emerging from this moment are unlike anything that has been written on American death row in a generation. There is one more layer to Act 1 that we must establish before we go deeper, and it is the layer that will come back again and again throughout this documentary like a recurring theme in a piece of music you cannot get out of your head. It is the question of the evidence. A significant number of the men currently on Angola's death row were convicted during an era of forensic science that we now know, with the benefit of decades of research and legal review, was deeply unreliable. Bite mark analysis. Hair fiber comparison. Blood spatter interpretation performed by examiners who lacked standardized training. These were techniques presented to juries in the 1990s and early 2000s as settled, reliable science. They were not. The National Academy of Sciences issued a landmark report in 2009 that fundamentally challenged the scientific validity of many of the forensic techniques that had been used to secure convictions in capital cases across the United States. The Innocence Project has spent 30 years documenting just how catastrophically wrong the forensic science of that era could be. And yet here, in Louisiana in 2026, the legal standard being applied is not whether the science was valid. The legal standard being applied is whether the original intent to commit the crime has been sufficiently proven by other means. The letters these men are writing are not just personal documents. Some of them are their last attempt to get someone, anyone, to look at the evidence again before the machinery reaches them. Think about that for a moment. Think about what it means to sit in a cell for 23 years knowing that the key piece of scientific evidence that put you there has been formally discredited by the scientific community, and to still be told that it does not matter. That the system has already decided. That the date is already being set. And here is the question I want you to sit with as we move into the next act of this documentary, and I want you to leave your thoughts in the comments because this is a question that does not have one right answer and your perspective genuinely matters. If the science that convicted a man is later proven unreliable, but the state still believes he is guilty based on other evidence, does the method of conviction matter? Does the foundation of the verdict matter? Or is justice simply about the outcome, regardless of how we arrived at it? Leave your answer below. Because the men writing these letters have a very specific answer to that question, and we are going to read it together. There is a moment that every man on Angola's death row has described in some form, in some letter, in some conversation with an attorney or a spiritual advisor, and it is the moment when the legal system stops feeling like something that is happening to you and starts feeling like something that is simply happening, a vast, impersonal, mechanical process that moves at its own speed, in its own language, according to its own internal logic, and that has very little to do with you as a human being anymore. It is the moment when you stop being a person in the eyes of the process and become a case number, a docket entry, a scheduled event on a calendar that someone else controls completely. And understanding that moment, understanding what it feels like from the inside, and what it does to the psychology of the men living through it, is the only way to understand why the letters being written at Angola right now carry the particular weight that they carry. We established in Act 1 the psychological arc of how men arrive at death row and what the decades of waiting do to the human mind. Now we need to go deeper into the machinery itself. Not the abstract idea of the justice system, but the specific, concrete, procedural reality of what it means to be a condemned man inside Louisiana's legal apparatus in 2026. Because the system these men are navigating is not a simple straight line from conviction to execution. It is one of the most complex, layered, contradictory, and at times genuinely bewildering legal structures in the entire American judicial framework. And the letters these men write are shaped, at every level, by their experience of moving through that structure, or more accurately, by their experience of being moved through it, like objects on a conveyor belt that occasionally stops, reverses, changes direction without warning, and then starts moving again faster than before. Let us begin with the appeals process, because this is the part of the system that consumes the most years, generates the most correspondence, and produces the most profound psychological effects on condemned men and their families. When a man is sentenced to death in Louisiana, his legal journey does not end with the verdict. It is, in a deeply ironic sense, just beginning. The American capital punishment system is built on a multi-layered appeals architecture that was designed, in theory, to catch errors, to provide a series of safety nets that would prevent the execution of innocent people or people whose constitutional rights had been violated during their trial. In theory, this is a noble and necessary system. In practice, for the men inside it, it functions as something that feels much closer to psychological purgatory. The direct appeal comes first. This is the automatic review of the trial record by the Louisiana Supreme Court, looking for legal errors that occurred during the original proceedings. This process alone can take years. If the direct appeal fails, the condemned man moves into post-conviction relief proceedings, a separate track where new evidence can be introduced, where claims of ineffective assistance of counsel can be raised, where constitutional violations that were not apparent at the time of trial can be argued. Post-conviction proceedings can generate their own appeals, their own counter-appeals, their own procedural disputes that have nothing to do with the underlying facts of the case and everything to do with whether the right form was filed in the right court within the right time frame. Then there are federal habeas corpus petitions, applications to the federal court system arguing that the state proceedings violated the condemned man's federal constitutional rights. Then there are applications to the United States Supreme Court. Then, as execution dates approach, there are emergency stays, last-minute evidentiary hearings, and clemency petitions to the governor. Each one of these stages generates paperwork. Each one generates correspondence. Each one requires the condemned man to revisit, in excruciating detail, the worst moments of his life and the worst moments of his victims' lives, over and over and over again, for decades. And each denial, each time the system says no, we have reviewed this and the answer is still no, lands on a man who has been living in a concrete cell waiting for that answer, and the psychological impact of that denial is not simply disappointment. It is something that researchers who work with death row populations describe as cumulative legal trauma, a specific and documented form of psychological damage that accumulates across years of repeated exposure to hope, denial, until the mind begins to develop its own protective mechanisms against the cycle. This is where the letters become a survival tool rather than simply a communication tool. Because when the legal process has stripped a man of agency over almost every dimension of his existence, when he cannot control when he sleeps, when he eats, when he exercises, when he speaks to another human being, when he learns whether he is going to live or die, the letter becomes the one domain where he retains complete sovereignty. No one can tell him what to write. No one can edit the letter before it leaves the cell. No one can stop the thoughts from forming on the page. The yellow legal pad is, in the most literal sense possible, the last piece of territory that belongs entirely to him. And the men at Angola know this. They have always known this. Which is why the letters are so dense, so carefully constructed, so psychologically layered that forensic linguists spend months analyzing what a single letter is actually doing beneath the surface of its apparent content. Now let us talk about what is happening specifically in 2026, because the systemic context of this particular moment is unlike anything that has occurred at Angola in the modern era, and the speed and intensity of what is unfolding is having a direct and measurable effect on the letters currently being written. After 15 years without a completed execution at Angola, the state of Louisiana has reactivated its capital punishment machinery with an urgency that legal observers across the country are describing as unprecedented in its pace and scope. Louisiana Attorney General Murrill has been explicit and public about her office's intention to move through the existing death row population systematically, using a legal strategy that prioritizes what her office calls expedited finality, a framework that argues, in essence, that the decades-long delays in carrying out lawful death sentences are themselves a form of injustice, both to the victims' families who have waited for resolution and to the integrity of the judicial system that issued the sentences. This is not a fringe legal position. There are serious constitutional scholars who support some version of this argument. There are also serious constitutional scholars who argue with equal force that the length of time a man spends on death row before execution is itself a form of cruel and unusual punishment, a position that has been upheld in legal proceedings in other countries and argued before American courts without yet achieving a definitive ruling. What this legal debate means in practice, for the 56 men currently on Angola's death row, is that the procedural landscape they have been navigating for decades has shifted dramatically and suddenly beneath their feet. Legal strategies that were viable 2 years ago are being foreclosed by new procedural rulings. Appeal windows that seemed open are being narrowed or closed by the pace of the state's filing schedule. And the psychological effect of watching the machinery accelerate after 15 years of relative stillness is something that the attorneys who work with these men describe as acute and destabilizing. Men who had psychologically adapted to an indefinite wait, men who had, against all odds, built something resembling a stable interior life within the constraints of their sentence, are now confronted with real dates. Specific months. The sudden, concrete reality of an approaching end that had for so long remained abstract. And this acceleration is producing a very specific and documented change in the letters. The forensic linguistics research we referenced in Act 1 identified something that the researchers called the final articulation surge, a pattern where condemned men whose execution dates become newly concrete experience a dramatic increase in both the volume and the psychological complexity of their correspondence. They write more. They write faster. They write with an urgency and a depth that is qualitatively different from anything in their previous correspondence. It is as if the approaching deadline, the most final deadline any human being can face, unlocks something in the mind that years of abstract waiting kept sealed. And the content of this surge writing is extraordinary, because it is in these letters that the 3 secrets we introduced at the beginning of this documentary come most vividly and most dangerously to life. Let us talk about the spiritual advisor situation, because this is one of the most legally significant and least publicly understood dimensions of what is currently happening at Angola, and it connects directly to the letters in ways that the state's legal team is actively working to contain. Under Louisiana's revised execution protocol, condemned men have the right to have a spiritual advisor present with them in the execution chamber during the administration of the nitrogen hypoxia procedure. This was a hard-won legal right, established after significant litigation, and it was presented publicly as a humane accommodation, a recognition that a man facing death has the right to have a representative of his faith present with him in his final moments. And on one level, that is exactly what it is. But on another level, one that the attorneys representing several of Angola's condemned men have been quietly developing for months, this accommodation has created an unexpected and genuinely significant legal vulnerability in the execution protocol itself. Here is how it works, and you need to follow this carefully because it is subtle but its implications are profound. Under the current protocol, the spiritual advisor is permitted to be present in the chamber and permitted to speak with the condemned man until a specific procedural moment, the point at which the nitrogen flow begins. At that point, correctional officers are instructed to manage the chamber environment in ways that may require them to physically intervene if the condemned man or anyone present behaves in ways that are inconsistent with the protocol's requirements. Now, several of the men on Angola's death row have begun incorporating specific religious language and specific religious practices into what they call their final letters, letters that are written in the final hours before execution and that contain embedded instructions for their spiritual advisors regarding specific prayers, specific spoken phrases, specific ritualistic responses that the advisor is required to make during the execution process itself. These instructions are written in religious language, framed as matters of sincere religious practice, and they are constructed with sufficient legal precision that any interruption of these practices by correctional officers could constitute, according to the attorneys making this argument, a violation of the Religious Land Use and Institutionalized Persons Act, a federal statute that provides robust legal protection for the sincere religious practices of incarcerated individuals. In plain language, these letters are not just goodbye letters. Some of them are legal instruments. Some of them are designed to create, in real time, during the execution itself, a set of circumstances that could generate grounds for a civil rights lawsuit, or potentially, in the most aggressive legal theory being advanced, grounds for an emergency judicial intervention even after the execution process has begun. The state knows this. The attorneys know this. And the letters are the mechanism through which this legal strategy is being operationalized, one careful, religiously framed sentence at a time. This is the machinery that runs beneath the surface of what looks, from the outside, like a simple collection of final correspondence. These are not simple documents. They are the output of human minds that have had 20+ years to study the system that holds them, to understand its vulnerabilities, to find the places where its authority is not absolute, and to work those places with the only tool available to them: a pencil, a yellow legal pad, and time. Now let us turn to the victims' families, because any honest examination of this system that does not center the experience of the people who were harmed by the crimes that put these men on death row is not an honest examination at all. It is easy, when we spend this much time on the psychology and the legal strategy of the condemned, to lose sight of the human beings on the other side of this equation. The mothers and fathers and children and siblings of murder victims who have been waiting, in their own kind of purgatory, their own version of the indefinite wait, for something that they were told would bring them closure, and that keeps being delayed, reconsidered, litigated, and deferred. Their experience of this system is real, and it is devastating in ways that are completely different from but not less significant than the experience of the men in the cells. The families of victims in Louisiana capital cases have been promised, repeatedly and by multiple administrations, that justice would be carried out. They have watched 15 years pass without a completed execution. They have attended hearings. They have given victim impact statements. They have navigated their own complex and often contradictory feelings about capital punishment, about whether watching a man die would actually give them what they need, about whether the system that convicted the man who harmed their family was actually as reliable as it told them it was. Because many of these families, as the forensic science debates have become more public, as the Innocence Project cases have become more prominent, as the reporting on bite mark analysis and other discredited techniques has become more widespread, many of these families are now carrying an additional layer of anguish. The anguish of uncertainty. The possibility, however small or large, that the system they trusted to find the right person did not, in fact, find the right person. This is not a comfortable thing to sit with. It is not a comfortable thing to write about or to watch a documentary about. But it is the truth of where many victim families in capital cases in this country find themselves, and the letters from death row speak to this reality directly, because some of the men writing those letters were convicted on evidence that is now scientifically contested, and some of them have been writing to victim families directly, not to intimidate, not to manipulate, but because after 20 years of living inside the same legal case, the boundaries between perpetrator and victim, between the guilty and the wrongly convicted, between the man who did it and the man the system says did it, have become more complicated than the original verdict could ever have anticipated. The system did not design a process for this complication. The system does not have a clean procedural answer for what happens when the science breaks down after the sentence is handed down. And so the letters become the place where this complication lives. They become the archive of everything the system cannot process. They become, in the end, the most honest document in the entire case, more honest than the trial transcript, more honest than the appeal filings, more honest than the press releases from the Attorney General's office, because they are written by human beings who have nothing left to perform for and no audience left to impress except the ones who might actually be listening. And the question I want to leave you with at the end of this act, the question I want you to think about as we move into the psychological aftermath, into the scars that this system leaves on everyone it touches, is this. When a system is this complex, this layered, this slow, and this absolute in its final outcome, who is it actually serving? When the process takes 25 years and costs millions of dollars in legal fees on both sides, and produces outcomes that are still contested by serious legal scholars, and leaves victim families in a state of perpetual unresolved grief, and leaves condemned men in a state of psychological suspension that researchers have documented as a form of psychological damage in its own right, when all of that is true simultaneously, what is the system actually doing? Is it delivering justice? Is it performing justice? Or is it simply perpetuating itself, feeding its own machinery, generating its own complexity, and leaving the letters, the handwritten, pencil-on-yellow paper letters of the men inside it, as the only artifacts that tell the full, unfiltered, psychologically complete truth of what it costs? Leave your thoughts in the comments. I want to know what you think this system is actually designed to do, and whether you believe it is doing it. Because in Act 3, we are going to look at the scars, and once you see them, you will not be able to look at this system the same way again. There is a particular kind of wound that does not bleed. It does not show up on an X-ray. It does not respond to medication or surgery or any of the clinical interventions that modern medicine has developed to address physical damage to the human body. It is the wound that is left behind when a human being has been inside a system this total, this absolute, and this prolonged, and it does not matter which side of the steel door you are standing on. The scar that Angola leaves, the scar that the American capital punishment system leaves, does not discriminate between the condemned man in the cell and the corrections officer who walks the corridor, between the victim's mother who has attended 30 years of hearings and the attorney who has filed 30 years of appeals, between the warden who signs the paperwork and the spiritual advisor who holds the worn book and waits. Everyone who enters the orbit of this system for long enough comes out carrying something they did not have before they went in. Something that does not have a clean name in ordinary language but that psychologists, trauma researchers, and the people who have lived it all describe with remarkable consistency. It is the feeling of having been permanently altered by proximity to the machinery of state-sanctioned death. And in 2026, as that machinery accelerates at Angola with a speed and intensity not seen in a generation, the question of what this system costs, not in dollars, not in legal hours, but in human psychological damage spread across every person it touches, is more urgent and more unanswered than it has ever been. Let us begin where the deepest wound lies, which is not, perhaps, where you expect. Let us begin not with the condemned man but with the corrections officers, because this is the group whose psychological experience is almost never examined in mainstream coverage of capital punishment, and whose suffering is both the most invisible and, according to the research, among the most severe of anyone in this system. The men and women who work Angola's death row unit did not sign up, in most cases, with the intention of participating in executions. They signed up for a corrections job in a state with limited employment options, in communities where the prison is often one of the largest employers within 100 miles. They went through their training. They learned the protocols. They did their shifts. And then, at some point in their career, they were assigned to a unit, or a team, or a specific procedural role that placed them in direct operational proximity to the execution process. And what the research on correctional officers who participate in executions shows, research conducted by criminologists, by trauma psychologists, by Veterans Affairs researchers who recognize the parallels with combat-related moral injury, is that the psychological cost of this proximity is enormous, persistent, and almost entirely unaddressed by the institutional systems that created it. The specific psychological phenomenon that researchers have identified in execution team members is called moral injury, a term that was developed in the context of combat veterans but that has been applied with increasing precision to correctional workers who participate in capital punishment. Moral injury is distinct from post-traumatic stress disorder, although the two can and often do co-occur. Where PTSD is fundamentally about fear, about the nervous system's response to a perceived threat to life, moral injury is about meaning. It is the damage that occurs when a person is required, by their role within an institution, to perform an action that violates their own deep moral framework, even when that action is legal, even when they believe in some abstract sense that it is justified, even when they perform it without hesitation or outward distress. The violation is not of the law. It is of something interior. Something that does not have a formal name in the employee handbook but that the human conscience tracks with absolute precision regardless. Studies of execution team members in American prisons have found rates of major depression, substance abuse, post-traumatic stress, and what researchers call complicated grief that are dramatically higher than in the general correctional population and comparable in many cases to rates found in combat veterans. These are people who went to work, did what their institution required of them, went home, and then found over the following months and years that something in the way they processed the world had been permanently rearranged. Former execution team members have described it in ways that are strikingly consistent across different states, different decades, different execution methods. They describe a specific recurring experience, a moment, often mundane and unpredictable, when they suddenly and without warning re-experience a sensory detail from the execution chamber with full psychological intensity. Not as a memory they chose to access. As something that surfaces without permission and carries with it a weight that ordinary memory does not carry. This is the scar on the people who pulled the lever. And at Angola in 2026, as the execution schedule accelerates, there are more people being assigned to execution teams, more people being rotated into roles that will leave them carrying this weight, and the institution's capacity to support them psychologically is, by every available account, wholly inadequate to the scale of what is being asked of them. Now let us move to the attorneys, because the legal professionals who represent condemned men on death row carry their own version of this wound, and it is one that the legal profession is only beginning to acknowledge and address with any institutional seriousness. Capital defense attorneys, the lawyers who spend years, sometimes decades, fighting to prevent the execution of their clients, operate in a professional environment that is almost uniquely designed to produce catastrophic psychological damage. They work in a field where losing means something categorically different from losing in any other area of law. A corporate attorney who loses a case faces financial consequences for their client. A capital defense attorney who loses a case faces the death of a human being they have come to know with extraordinary intimacy over years of intensive legal work. They know their client's childhood. They know their client's trauma history. They know the details of the crime with a depth that most people in the case do not have. They know the letters. They have read every letter. And when the final appeal is denied and the execution date is confirmed and there is nothing left to file and nothing left to argue, they experience something that psychological researchers have described as anticipatory grief combined with professional helplessness, a combination that the legal profession's culture of stoic competence makes almost impossible to acknowledge, let alone process. Multiple studies of capital defense attorneys have found that burnout rates, depression rates, secondary traumatic stress rates, and rates of leaving the profession entirely are dramatically higher than in other legal specialties. And the attorneys who stay, the ones who continue to take capital cases year after year, who continue to sit with clients on death row and read their letters and file their motions and drive to Baton Rouge and argue in courtrooms and then drive back to Angola to sit with their client again. These attorneys describe a psychological adaptation that sounds, when they articulate it honestly, remarkably similar to what researchers have documented in the condemned men themselves. A gradual reconstruction of their relationship to hope, to outcome, to the meaning of their work. A shift from believing that the system can be moved to believing that bearing witness, being present, being thorough, ensuring that every argument is made and every right is exercised even when the outcome is not in doubt, is itself a form of justice, even when it does not prevent the death. This is the moral architecture that the system builds in the people who fight against it from the inside. And it is as much a part of the scar as anything else we are examining today. Let us talk now about the families of the condemned, because they occupy a position in this system that is almost completely invisible in mainstream coverage and that involves a form of suffering that has no formal name and no designated support structure within the judicial process. The mother of a man on death row is not a defendant. She is not a victim, in the legal sense. She is not a party to the proceedings. She has no formal standing in the process that is moving toward the death of her child. She can write letters. She can attend hearings if she has the money to travel and the emotional capacity to sit in a courtroom and listen to arguments about whether her son should live or die. She can visit, within the strict constraints of Angola's visitation protocols, for limited hours, through plexiglass, on a telephone. And she can wait. For decades. She can wait and watch her child age behind a steel door, watch the appeals fail one by one, watch the legal language pile up around him like sediment, watch the dates get set and stayed and reset, and carry within herself a grief that is unlike any other form of grief that human beings experience because it is anticipatory grief with an indeterminate timeline, the grief of a death that has been promised but not yet delivered, that could come tomorrow or in 5 years, that the state holds the schedule for and that she has no power to prevent or accelerate or in any way influence. Researchers who study what they call ambiguous loss, a term developed by family therapist Pauline Boss to describe grief that lacks the clear endpoint of a traditional bereavement, have written about the families of death row inmates as one of the most psychologically isolated populations in the American grief landscape. They do not fit the category of bereaved because their loved one is still alive. They do not fit the category of crime victim because they are not the people who were harmed by the crime. They exist in a space between these categories that the social support systems of their communities, their religious institutions, and their mental health infrastructure are almost entirely unprepared to address. And they carry this alone, in most cases. Because the social stigma of having a family member on death row is itself a form of ongoing trauma, the constant management of other people's judgment, the constant decision about who to tell and what to say and how to explain a reality that most people in their lives will never come close to understanding. And yet these are the people who receive the letters. These are the primary recipients of the yellow legal pad pages that leave Angola's death row unit. And what the letters do to the people who read them, what it means to hold in your hands the handwritten words of someone you love who is writing to you from inside a death sentence, is something that no research study can fully capture and no documentary can fully convey. It is the most intimate form of communication that the system allows, and it carries within it the full weight of everything we have been examining in this documentary. The psychology of the condemned man. The legal strategy embedded in the religious language. The forensic science debates. The moral injury of the officers. The grief of the attorneys. The unresolved anguish of the victim families on the other side. All of it converges in the moment when someone sits down at a kitchen table somewhere in Louisiana and opens an envelope postmarked from Angola and begins to read. Now we must return, one final time, to the men in the cells themselves, because the scar that this system leaves on the condemned is the one that is most documented, most researched, and in some ways most difficult to look at directly. Not because it is the most dramatic, but because it is the most complete. These men have been inside this system long enough to have been shaped by it at every level, physically, cognitively, psychologically, spiritually. They have been changed in ways that are not reversible. And the letters are the evidence of that change, the most detailed and authentic record available of what happens to a human mind that has been placed in solitary confinement, deprived of natural light and normal human contact, subjected to the repeated cycle of hope and denial across decades, and then told that the end is approaching. What the letters reveal, when you read them with the framework of forensic psychology and the understanding of what these men have been through, is not what most people expect to find. Most people who learn about final letters from death row expect to find rage, or manipulation, or performances of remorse designed for clemency boards. Some of that exists. But what dominates the letters from the long-term Angola population, the men who have been there for 20 or more years, is something more surprising and more psychologically significant. What dominates is clarity. A specific, hard-won, costly kind of clarity that emerges only from the particular crucible of extreme long-term isolation combined with the constant proximity of a known, state-scheduled death. These men have had no choice but to think. No choice but to examine. No choice but to sit with the worst things they have ever done and the worst things that were ever done to them and the worst things the system has done, and to think about all of it until the thinking produces something, not peace, necessarily, not resolution, but a kind of honest, undefended reckoning that most people who live ordinary lives never have to face and therefore never achieve. This is the paradox at the center of this documentary. This is the thing that makes the letters so extraordinary and so uncomfortable to read. The system that was designed to punish these men, to isolate them, to hold them in suspension until the machinery reached them, that system has also, entirely as a byproduct of its own operation, produced in some of these men a depth of psychological self-examination that is rare in any human being and that manifests in the letters as a kind of writing that is genuinely unlike almost anything else produced within the American criminal justice system. It is not heroic. It is not redemptive in any simple or comfortable sense. It is not an argument for or against capital punishment. It is simply what happens when a human mind has nothing left but time and a pencil and the knowledge that the next letter may be the last one. And the question, the final question of this act, the one I want you to carry with you into the concluding section of this documentary, is this. If the system produces this, if the decades of isolation and waiting and legal process and psychological pressure produce, in some of these men, a form of human depth and honesty and self-awareness that the system itself has no capacity to recognize or respond to, what does that tell us about the system? What does it tell us about what we are doing when we ask the state to hold a human being in suspension for 25 years and then execute him? Are we executing the person who committed the crime? Are we executing the person who has spent 25 years becoming someone the crime no longer fully defines? Or are we simply executing a case number, a docket entry, a scheduled event, and leaving the letters, the real person, the psychological truth, the handwritten evidence of a human life in full, to be read by someone else, somewhere else, long after the machinery has moved on? Leave your answer in the comments. Because in our final act, we are going to ask the deepest question of all, and the answer, I promise you, will not be what you are expecting.